This is on the California recall. The state's electors have the power to remove an elective officer, and it is done by initiating through the delivery of a written document to the Secretary of State, a petition alleging a reason for the recall. However, note that the sufficiency of the reason for the recall is not reviewable by a court. After delivering the petition to the Secretary of State, proponents have 160 days to file the signed petitions. A petition to recall a statewide officer must be signed by electors equal in number to 12% of the last vote for that office, with signatures from each of 5 counties equal in number to 1% of the last vote for the office in the county. Signatures to recall senators, members of the assembly, members of the Board of Equalization, and judges of the courts of appeal and the trial courts must equal in number 20% of the last vote for that particular office. Now, an election to determine whether to recall an officer and, if appropriate, to elect a successor must be called by the governor and held not less than 60 days nor more than 80 days from the date of certification of the sufficient number of signatures for the recall. A recall election may be conducted within 180 days from the date of certification of sufficient signatures in order so that the election can be consolidated with the next regularly scheduled election that occurs. This is allowed if the number of voters eligible to vote at the next regularly scheduled election equal at least 50% of all the voters eligible to vote at the recall election. Now, thereafter, if the majority votes to recall the state officer, then that officer is removed. And if there's a candidate, the candidate who receives a plurality is the successor to that office, not a majority or 50% plus one. The officer being recalled may not be a candidate. And note that a state officer who is not recalled must be reimbursed by the state for the officer's recall election expenses that were both legally and personally incurred. In addition, a recall cannot be initiated against that same officer until at least 6 months after the recall election has occurred. Now, California's Secretary of State has prepared a lot of information about the 3 forms of direct democracy and specifically on recalls. Since 1913, there have been over 165 recall attempts of state elected officials. 10 recall efforts collected enough signatures to qualify for the ballot. And of those, the elected official was recalled in just 6 instances. There have been 50 attempts at recalling the governor, 1 attempt of the lieutenant governor, 5 attempts at an attorney general, 1 of the insurance commissioner, 2 of members of the Board of Equalization, 28 members of the state Senate have been subject to a recall petition attempt, 50 members of the assembly, 1 Supreme Court justice, and 27 of the entire membership, and then 27 of individual justices. So the recall attempts that have actually qualified for the ballot, 1913, there were 2, both senators, Senator Black and Senator Grant. In 1914, Senator Owens, then nothing for 80 years. And in 1994, there were 2. Actually, there were 3. Senator Roberti, Assemblyman Machado, Assemblyman Horcher. The following year in 1995, Assemblywoman Doris Allen. Then in 2003, Governor Davis. In 2007, Senator Denham. And in 2018, Senator Josh Newman. And of course, in 2021, Governor Newsom. The only successful recall attempts have been 6. Senator Black in 1913, Senator Grant in 1914, in 1994, Assemblyman Horcher, in 1995, Assemblywoman Allen, 2003, Governor Davis, and the last successful recall was in 2018, Senator Newman.